Commissioner Adaro,
Here.
Commissioner Kasher,
Here.
Commissioner Wasserman,
Here.
Commissioner Wynn, Chair Remke.
Here. Okay, good afternoon. Thank you for coming. We're just going to get started here, and I'm going to start with public comment. Is there any public comment for a matter not on the agenda? Please.
Hi, my name's Gail Jackson. I'm from Secretary of State's Political Reform Division.
Might want to bring the mic down.
Is better? Okay, I just wanted to say that we've got 2 public hearings on the Cal Access Replacement System scheduled. The first one is February 3rd at the Ronald Reagan Building in Los Angeles. And we have one here in Sacramento and at the Secretary of State's office on February 9th at 10:30. We'd like to welcome everybody for comments on this new project.
Thank you. Thank you. And I think, Erin, we're going to post those on our website as well.
Right, and push them out to our listservs.
Okay, great. Thank you. Any other public comment before we get started? Okay, then approval of the December 2016 minutes. Any questions or comments from the commissioners before a motion? Is there a motion?
I move approval of the minutes.
I'll second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes. Commissioner
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, moving to the consent enforcement calendar matters 3 through 29. Before we get started with specific questions, are there any matters that the commissioner would like to pull from the consent calendar?
Yes. So we also have matters 9 and 33 from last month.
Well, they should be back on here, right?
Oh, are they?
Yeah.
They have new numbers incorporated from just in order on the
Okay,
agenda.
so then I have to, so eBay is number 5. I'd like that pulled, and whichever new number is for the LA County Museum of Natural History Board.
26.
26. So I intend to recuse myself. I'm a partner at a law firm called Paul Hastings, and the respondents are the respondent subjects to the item are clients of my firm. And under the recusal section 87-105, I can't be counted toward achieving the quorum on these items. And if these items are considered outside the calendar, I will leave the room.
Okay, thank you. So we'll pull 5 and 26 and discuss and vote on those separately. Any other items that need to be pulled from the consent?
3 and 4, please.
Okay, items 3 and 4. As for the remaining items, 6 through 29, excluding 26, are there any questions from the commissioners on the remaining items on consent?
No.
Okay, any public comment on those remaining items on consent calendar? Okay, seeing none, is there a motion?
I will move approval of items 6 through 29, excluding item 26.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so then we'll just take each of the remaining matters in order, starting with number 3, the Mark Peterson matter. And Ms. West, do you want to go ahead and just state your name and for the record?
Galena West, Chief of Enforcement. Happy to answer questions you may have.
Did you want to start, Commissioner Wasserman?
Sure. As an aside, thank you folks for your well wishes about the family situation that caused me to be unable to attend last meeting. So I reviewed the video from the last meeting and I looked over the materials, and I guess in sum, the way I'm looking at this is that I look at it, we have prior case where someone has used $3,000 in campaign funds, stipulates to 3 counts and gets a fine of $15,000, and we have this case which involves, and correct me if I'm wrong on any of these facts, 66,000, 9 counts, 45,000. And I know we're trying to sort of figure out how we're going to approach things now as opposed to then with the changes that have occurred in the structure we're dealing with. But my inclination is that in order to find some proportionality and consistency, that for me, that this fine is not going to be enough. Especially as I compare, I listened to the arguments about, how people address instances of conduct and how much weight that is given, the development of counts versus instances, and then the question of actually how much money as being one factor in determining the severity and how we approach this. And I thought, well, though I still feel I have my concerns about the whole instance situation. If we look at the amount of money as the impact, the impact of the bad act, essentially, that the proportionality gets thrown off where, one egregious actor who deals in 3,000 comes up with 15, and one egregious actor who deals with 66 comes up with a $45,000 fine, given that because of the number of instances and potential counts that there is the conduct there that could substantiate a higher fine. Now, I understand the fact that this process involves a type of prosecutorial discretion and negotiation, etc. And I'm just saying that from my perspective, I would like to see, and I would like to see a bit of a continuity or an explanation as to why that, well, no, actually, I really would like to see continuity there between those two. Because I'm not sure if I could say that, the conduct by a council member, a sitting council member in one case was egregious such that you ended up with essentially a multiplier of 5 based on the amount of money, supported by the counts, because we have to use counts in order to impose these penalties, versus the egregiousness of a sitting district attorney in doing 66,000. Now, if you ran a straight multiplier, that would be considerable fine. But then I think about them and I think, well, but if that's what I personally would be comfortable with as being warranted, then that's what I would end up with. Granted, if you did 600 instances and actually did 600 counts, then you're looking at a potential of something like 3 million, which I don't think any of us would be pushing towards. And I think we'd have other issues to discuss about, when a body tries to do something to that extent, based on what could be like movie tickets here or this and that. But I think in some, accepting some of the arguments on their face, that's where I think that if we have a common ground to discuss it, that's where hopefully we have some common ground for the discussion, but I still disagree.
I understood everything except for the last sentence.
Well, because because we're constrained. One of the things that and correct me if I'm wrong, because I'm going to quote you back at you, and that's dangerous. So one of the comments that came up in the last meeting that I watched on the video had to do with what the value of the instances is in sort of determining what is an appropriate final penalty. I'm not saying penalty per count because we have a criteria for that, but I'm talking about the overall process that leads us to saying the stipulation with this many counts reaching this fine is appropriate. So while the that whole issue about instances and counts, I don't necessarily agree that instances are that minimal. But if we can agree that yes, the dollar amounts are of great concern, because that goes back to the whole question of why we don't want them using their personal funds. I mean, we don't want the opportunity for bribery where a donor gives money knowing that's going to benefit a candidate, or that even if a donor doesn't know it, that a candidate, looks at something as their personal piggy bank and then approaches their job differently because of that. So that's why I'm saying that's where if we're going to agree that the dollar figure is going to be what we're going to look at right now, if I agree with that premise, I still would disagree with 45,000 as where we end up in terms of the fine. Is that clarify that last
I think I get you now.
part?
Okay. Well, and using the Baca del Rio, I think that's something we discussed last time. I think that is it's not the benchmark that we want to use. That was a on-the-fly settlement that was done, as you know, in the hallway as we were trying to figure out a default that became a settlement. And so the analysis didn't go into that. The analysis of the hours that we put into these cases to figure out these amounts. So if you want me to compare it to that case, then yes, I will have trouble using Baca del Rio as a benchmark for any case. But that's because in my opinion, it shouldn't be used. It's not a well reasoned, thought out what we wanted to do. What we wanted to do was we were presented with a default. We wanted a certain amount of settlement because of the amount of the default. And that's where we came to. And I thought everybody understood that the day we did it. But that being said, comparing to Scott Mann, which is the one that was approved last time, then I think you can do a side-by-side comparison and you can come up with some sort of benchmark. Because as I was saying to Commissioner Adaro at the last meeting, I think it's the amount. I think what's the focus has become is the amount of the penalty. The amount of penalty is $45,000. The amount of the penalty is $45,000. Yes, that is true. But the amount of the reimbursement is $66,000. So we're talking about one pool of money, this guy's pocket, and it all came out of that pocket. So when you look at that and you look at Scott Mann, which I have some numbers, the total out of pocket for Peterson is $111,000 for reimbursement plus fine. Total amount out of pocket for Scott Mann, $72,000 amount of reimbursement plus fine. You can add $5,000 extra for record keeping. And so I think that's less money that was misused. That's less instances, whatever the other factors you want to put into. The amount of those two is different, and it's different for a reason. But it makes sense with the numbers and the penalty. So yes, this penalty does look smaller. It looks smaller because the other pocket paid for $66,000 of reimbursement. So I think if we keep these things in consideration, we realize we have gotten back $111,000 from Mr. Peterson. So I think that that's something that we should definitely keep in mind when we're looking at these cases, because if there's no incentive for people to pay back their campaigns, then they won't. And so stealing the money from your campaign, that money will never be reimbursed. The money will be paid to the state of California. So that's just a policy call that we have to make. Are we having the money go into a higher fine where it sounds better that they got fined $200,000 or $111,000, but don't reimburse your campaign? Or are we having them pay back what they took?
Well, there are two. I had one thing I wanted to go back to you on that. Now I have two. The first is, I tend not to look at what they have to pay back, because that's what they have to pay back. That's what they've taken wrongfully, and they're really essentially just in the position of making that public trust whole. So I don't really consider that when estimating and thinking about the penalty aspect, because
But that's part of settlement.
That would mean that the greater the wrong, the greater the mitigation by paying back. And I'm not entirely comfortable with that. We can disagree
think-
on that as a policy.
But I
but
think
I'm saying
that
I
you're misunderstanding what
disagree.
I'm saying.
Okay,
All these
let's clarify.
settlements have been partial repayment, full repayment, no repayment. If you look at all of the settlements through the history of the commission. So there's partial repayment, full repayment, no repayment. Shirakawa went to jail. No, you're not getting repayment. So it's a good theory to think of them making their campaign holes, but not realistic in every instance. So I agree that making it whole is important, which is why I think that Mr. Peterson making his campaign whole again is important, which is why it was given some weight.
You said you had one other thing, Commissioner Wasserman?
Yeah, so going back to the concept that Mr. Peterson, his out-of-pocket was 111, except that 66,000 of that was never his to begin with. So his pocket grew by 66,000, which he then put back. So really his out-of-pocket was whatever the penalty is.
I agree, but can I interrupt that the other people didn't put it back in the pocket? So they did ungainfully or unlawfully gain a certain amount of money, whether it be $40,000, $60,000, $10,000. But if they didn't fully repay it, we either have to set the policy that we make everyone fully repay and then look at fine, or we take it into consideration that it wasn't fully repaid.
But we can't
And
legally
so
do that. I mean, there's not a legal requirement that they fully repay.
we could make it a term of settlement
Right.
if that's what we decide. But in Scott Mann's case, he paid back 1/3. So he took $45,000, paid back $17,000. So yes, unlawfully gained that other amount of money. So that's all I'm saying
Okay,
is that
And fair enough. I understand the distinction you're making, and maybe this is the point at which we have a policy discussion. I'm new to this. I've been here for a year and some, and I don't know the mechanism to have a policy discussion. I know that I think it was September, Commissioner Kasher said, we should consider these on a case-by-case basis. And I have a concern about that because if we don't have a policy as a starting point, I think these case-by-case considerations become what, and I put this term on it, but more an art than a science based on the discussion that we were having last month. And I just don't think that that's the appropriate way to analyze these cases. I think that there is some level of discretion, but I think that we have to be very careful with how discretion is applied, because I can see Ms. Vaca del Rio coming back and saying, hey, why was I treated differently?
Mhm.
Why, especially compared to a sitting DA who is and we can go into all of these factors, right? Aggravating and mitigating, but we have to be able to explain them. And the problem that I continue to have over Peterson is that I just don't, like I said last time, and I haven't heard anything different, and maybe there will be time later today, but I just don't see the consistency in what we're doing. And so that's one point. But the other point is I don't think that people should be allowed to use the campaign funds as their personal bank account. And just because they pay it back, suddenly it's okay, or it's not as egregious. I think that people should pay the money back. And, maybe this is a policy consideration and we can go about it through settlement and whatever, but beyond paying the money back, they should be punished equally, because otherwise we're saying it's okay, go ahead, use this money as your slush fund. I could be a contributor. I have no intent that money be used for somebody's wedding, as was the case in Mann, or Peterson for restaurants and movies and whatever he used it for. My intent is, I want you to use it for your campaign. Otherwise, give it back to me if you're not going to, because that's my expectation under the law. The fact that you may later pay it back makes no difference to me. The fact that somebody went in and stole something twice and later put it back, the person still had the same intent in stealing it. And so that's where I have a little bit of a concern with how we're addressing and the policy that I think is being set in some unofficial kind of way regarding just forget Baca del Rio. Let's say Baca del Rio, as you said last month, was, somebody that you wanted to throw the book at, but that at the end of the day, it wasn't how enforcement would have handled it. Let's forget her for now. There was no consistency between Peterson and Mann, and that's the concern that I have. And I've said everything. I know that Commissioner Wasserman had more to say, and I may come back and say more, but that's my response to the issue of the out-of-pocket.
And I agree. If you don't take back the amount that was paid back, if you don't take that into consideration, they don't look even. But if you do, then they come out to the total out of pocket to the total misuse is within a couple percentage points of each other.
But they're not paying it back out of their own pocket. That's the point.
They are paying it back out of their own pocket.
No, they took Peterson took $66,000 from the campaign, and then he put it back. That's not his money. His personal bank account and his funds are at net.
And Mann took $45,000 and paid back 17 and kept the rest.
Okay, I don't disagree.
So
that
paid part of his fine with that money.
Well, I don't disagree, but I think that then we have to make sure that we are making everybody pay back and then treat everybody equally. And I think that the numbers don't play out that way, is all I'm saying.
Okay.
Commissioner Wasserman, did you want
Well, one of the thoughts.
Then I'm going to give the other commissioners
Sure,
an
of
opportunity
course.
to speak as well.
Of course. One of the things when we talk about paying back, they're paying back to their campaign account. Correct.
That's correct.
Yeah. And I mean, that may be another reason why, as I approach the issue, the way I look at that, because they're really paying back to the other pocket. It's still not supposed to be for their personal use, but it still is in furtherance of their purposes, their goals, and what they want to accomplish. So I don't treat it dollar for dollar in my mind. I'm trying to get to the heart of why this troubles me.
So you prefer a higher fine with less repayment? I'm just trying to understand.
Yeah, no, I no, it's a fair question. If someone is forced into that situation where it's one or the other, I'm not sure which statutory which idea trumps. Because
are you more
someone was
comfortable
going to do
with
that today, and it had to be me apparently.
Are you more comfortable with the Mann settlement where he didn't pay it back and he had a higher fine, or the Peterson settlement where he paid it all back and has a lower fine? Which scenario?
Well, I think you were trying to say that it all comes in the wash because the dollars come out at the end, and I'm just saying that probably between those ones, I'm probably more comfortable with the fine because that's out of the hands of someone who has now demonstrated that they've breached the trust. But I mean, I don't know, when they pay it back, is there an opportunity for donors to get money back from them? No, it's just in the fund to be used for other purposes, political purposes,
An
etc.
opportunity not to vote for him the next race.
And that's certainly always the option of the informed electorate.
Well, then I think that's part of our job. I'm going to try to let the other commissioners. Commissioner Nguyen, did you want to start?
Yes, thank you. And I did speak last month too, so I'm going to keep it very short. So, I mean, certainly this is a difficult case, and it's an evolving policy discussion, and one that we should agendize for some later date and have that conversation about reimbursement versus a fine. I think that's a legitimate conversation to have, and I'm glad you kind of teed it up that way. And clearly, I agree that you should not be able to use campaign funds as your personal, wallet. But I do really think that a $45,000 fine is a very significant fine, and I'm sure that Mr. Peterson and those that follow will take that into account when they, want to go to the movies and they only have their credit card for their campaign. So, I support this stipulated settlement, and that's all I have to say on it today.
Commissioner Kasher?
Yeah, I don't want to bury the lead. Likewise, I support the proposed penalty in the staff report. From my perspective, I think it's important that that staff has some flexibility in its ability to negotiate these settlements. As I understand it, there's a complaint that's filed. There's an investigation. The party is informed of the different violations that have been determined, and it's staff's duty to go out and investigate and gather evidence and do what it can to find a reasonable settlement. And we get a staff report that has, information in here, but it's not all the information. And that's how it is, because some of it's confidential. I don't see the comparable cases as precedent. They're comps. So these are the types of cases that have come before the commission that are very similar, but they're not, I don't see them as precedent. They're guidance, but they're not anything that should determine what the next case should be. And I frankly think that, for a case, some of these cases go on for years, and staff is intimately involved with the facts in negotiation in conjunction with the party involved. You're in a good position to make a determination as to these issues. We look at, when I look at these fines, I'm looking at, is it punitive? So it's going to be a deterrent. And I think a $45,000 fine in this instance is, but I also think, and I share the sentiment of Commissioner Ardero, that the public and then also the regulated community has an interest in knowing how we arrive at these calculations. The most impacted individual is the gentleman who's being fined. And once he is under investigation and he's having these discussions, I would expect for his attorney to get into the details of some of these comparables and say, hey, maybe this isn't fair, or they can have those conversations. And if the general public is interested and would like further information, they can attend a meeting and ask during public comment or during the meeting and ask some of these details and this information. But if I'm advising someone in the regulated community, I'm telling them this is the maximum fine for these violations, and that's the starting point, and everything else arises from that, and it's a negotiation. So I'm comfortable with the approach on this particular case. I'm comfortable with the proposed penalty. I appreciate the discussion and the comments from my fellow commissioners. I think that this is an important discussion, and I share Commissioner Wynn's thoughts on maybe this is something that can be agendized for a later meeting with some very specific points that can be discussed, because I think staff would probably benefit from some direction on this, so that there can be some clarity on these issues. But that's kind of where I'm at this point.
And just let me jump in. As far as putting this on the agenda, I'm fine with it. I guess as I kind of mentioned earlier, though, us calling it a policy that we wouldn't settle cases unless all the money's paid back is somewhat problematic for me for two reasons. Number one, again, I think we could talk about proposing a legislative change to make it the law that any personal use of campaign funds must be paid back. But once we start making that a condition, I'm just a little troubled by that, and perhaps I would prefer to see that go to the legislature. But the second reason being that I do think we start getting into tying the hands of resolving these cases. And again, Mann did not pay it all back, but he did pay a $60,000 fine. And more importantly, the violation has been acknowledged and known. And I think that goes back to my other point. Part of the deal here, yes, we have a limited jurisdiction what we can do, which is a fine, and to get the violation and the misconduct out to the public as soon as possible. And as soon as we start tying our hands to settlement opportunities, cases are going to be delayed, because they are delayed considerably as they go through an ALJ process, which means, in fact, there may be another election for some of these people before the case is even resolved. I always encourage settlement to keep this process moving, and it's absolutely mandatory that it does continue to move through settlement. Otherwise, we would have start creating a backlog of cases that would be really something we can't handle. So again, I'm fine with talking about this mandatory payback, but again, I would encourage that discussion to be that we consider voting for a legislative proposal.
Well, No, I'm not into. Actually, you took one of the things I was going to say is that one of the issues here is that really there are. As you look at this kind of violation, and you think, well, maybe is there some legislative fixes that could be in place? Not. We were trying to think of it, but I couldn't find obviously a perfect solution. But we're thinking through the part of the problem is we tend to have these policy discussions on a case by case basis, and I still think we should have the policy discussion. Or somebody should have that going forward, because what the chair was saying, certainly you don't want to declare a policy on the basis of this one case without notice and comment and all these sorts of things. And some things may not be fit for us to make a decision about it and really should go to the legislature. For example, the question of as we're trying to compare fact patterns, if you have a person who takes $100,000 but only has one count because there is really only one instance they did, so there's only the evidence to support one count. Then you have someone who yes, they may pay back the whole 100,000, but we're limited to a $5,000 fine. Or you'll have people who have maybe 3,000 total and maybe have done 40 different acts. That's not something that enforcement can quote fix in terms of making them proportional and even, because that's not how it's set up. So that's one that I think is worth thinking about in the future, because we have other mechanisms. We have other types of violations where you might have disgorgement. There are other ways of having a formula of percentage penalty that would actually capture the extent of the wrongdoing, even if it's only in one single count in one single instance. So I'm in agreement with the chair about how some of these things we come back to, but there's probably a better way to do it. And I'm also in agreement with, and this is where I have to cut this hair kind of thin. It isn't that the fine itself doesn't fall within a range that I feel is appropriate to say this is serious and this is we're sending the right message. There was a case, I think it was 14130, which was $93,000, and it was $3,500 fine. And at that time, my argument was that the cost of doing business, if someone had borrowed that money from a legitimate source, it would have cost them more. So I'm not saying it's like that case, because this is certainly, $45,000 on a $66,000 misuse of funds is not even in that category. What I'm really talking about is trying to get into the transparent aspect of how we get there and the proportionality and the consistency, because it's like what you're saying is the number in the end has the recipe, but it's not so easy to just sort of look at that number and understand how that recipe came about. Because otherwise you get this situation like Commissioner Darrow was saying, well, why does this person get this and that person get that? And that's where the difficulty becomes. And I'm not entirely sold, just because of the magnitude of consistent misconduct and frankly the status of the respondent, their sophistication level, which I would consider on the range of sophistication pretty high up there, even among the number of elected officials we've had who are maybe 3-term council members or whatnot. So that's where for me it feels like the statement needs to be even stronger, because the extent of the conduct, etc. Granted, you have to do what you have to do in terms of all of the priorities that the chair was talking about, trying to get these things through. And I respect that, but I still have my issue there.
And I echo what Commissioner Wasserman said, because we share the views on this. I do want to address something that, and maybe again, we need to put this on the agenda to discuss another day, and happy to do that. But I do think that a lot more weight is given to the fact that we need to give staff discretion to negotiate behind closed doors than I think is warranted. I do agree that you have a duty to investigate, as Commissioner Kasher was saying, but I think that everyone is entitled to understand what facts were used to determine what how you arrived at a particular penalty. Months ago, I can't remember who it was, but said that there was a mediation privilege that precluded that. I disagree. The mediation privilege doesn't apply here. I understand that there may be some confidential information, but I don't think that information should be kept from the commissioners. And there is a mechanism for, a closed door meeting where we've done that before, at least once since I've been here, where we can share information that perhaps is of the nature that can't be shared to the public. And I
We'd have
understand-
to have the other side there, otherwise it would be ex parte communication.
Okay, well, and then do it in open meeting. But I don't think that we are meeting our obligation. And quite frankly, the entire commission's goal that was stated to me when I first came on, that I agree with, of transparency, when we keep certain facts out of the picture and then just kind of call it an art rather than a science on how we determine penalties. I think that both the regulated community should know, and I think that the public should know. And so that's my personal belief on that. So that's what I have to say about that particular point.
Any more comments before we ask for public comment? And again, there were a number of letters submitted, which are part of the record and available online as well. So any public comment here? Okay, seeing none, is there a motion?
I would make the motion to not accept the stipulation and direct staff to come back and see if they can come back with either a higher proposed penalty or proceed in another fashion enforcement against respondent.
I second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
No.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke.
No.
This motion does not pass.
Are there any other motions on item 3?
I move approval of the staff recommendation stipulation.
Second.
Commissioner Adaro,
No.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
No.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Thank you for the discussion. So next is item 4. Michael Horner, the default decision in order. And I'll note for the record that Mr. Horner submitted an email on Saturday, the 14th, which has been posted as well. Correct, Shiva? Yes.
Mhm.
Is there any discussion
I
from the
have-
commissioners?
Yeah, I have a question.
Commissioner Wynn?
Thanks very much for this report. So I was surprised to get the email, after, this 100-page pages of how, we ended up going to default. But you did have a paragraph in your staff report about he did cooperate. He admitted that he had made a mistake and he did cooperate. Although, when you look through the default process, it doesn't look very cooperative. So I wonder if maybe you could just help us figure out, like, how did we get here? And then a late night email saying, it's unfair, it's too much. And
can I just jump on that question? Give me, if in answering it, can you give us a general timeline of maybe the first time he was contacted and the last time we had reached out to him before we got to here?
Sure, certainly. So I think cooperate might be too strong of a word to start with that. So he cooperated in that he spoke with the investigator. I mean, there's some cases where they won't even, you subpoena them, you have to make a motion and you have to do a lot of things that you have to go through just to get to them to talk to you. And in this case, he spoke to the investigator. So I think that was the loose definition of cooperation.
And made somewhat of an acknowledgement of the wrongdoing, correct? Wasn't that quoted
He
somewhere in
did.
there?
admit to everything. So the investigator felt that it was cooperation. So back in June of 2015, he was first contacted. And that's when he was interviewed by our special investigator, Paul Racy. And he was talked to and told about his violation and that he had to remedy it. And so that's when he started to understand what was going on. Then we had to subpoena him for information. And so then that took a little while. And then February of this year, he was first reached out to for settlement, because the main goal was, since he didn't file anything and his name wasn't on the mailer, was to get the filings done in his local jurisdiction. And so the campaign statements were emailed to him. We offered to file them for him. We offered a bunch of assistance in getting him to comply with the disclosure portions of the case. And he declined to participate at that point. And so then he was given his probable cause report, and and he was given an extension for an extra month to come up with settlement funds. And then he just stopped participating in the process. So this email was, he hadn't started responding again until he got notice of the default.
If I could just finish then my thought, I'd have a lot more sympathy for Mr. Horner if there had been more cooperation, but it just seems a little too, it's too little too late in my mind. And, our commission has been fairly strong on defaults. And, I might be one of the commissioners that feels the most strongly about that. So, I don't have much sympathy for someone who really just didn't come to the table and address this.
I agree. I'll just state, and also just because I think as he mentions, he's still willing to resolve it if we offer him a reasonable fine. Well, you did offer settlement. If he didn't want the settlement, he obviously had his rights to go to an administrative law judge and get argue his best case and hope for, what he thought was a better deal. So again, I think the default process has been fully explained here, and I'm prepared to move on this as well.
Well, kind of hope you guys might reconsider. I love the agendas where I'm in one thing saying, we're going to be harder, and then I come around to the other one and I say, yes, cooperate was probably a strong word, but you're right. Given the world that we operate in, that is cooperation. I mean, for someone to even communicate with us before we hit them with the, hey, by the way, we've defaulted you. The thoughts I'm thinking about this, and I feel like we've kind of already opened this door before. It's not a door necessarily wanted to open, but we kind of have. We've had a former state senator sort of run in with a check to avoid default. We had the case we're talking about previously, where I think we had a 6-figure default, was it at that point initially? And someone coming in, et cetera, who are much more sophisticated than essentially what we would call a self-represented respondent, who, at least on the record we have, doesn't have a prior history with the FPPC or anything that would indicate that they should have the sophistication and expertise to really understand that, no, we mean business. We've called you. We've mailed you. I mean, you would think those things would make an impression, but as a matter of, again, consistency and fairness, I'd be willing to push this over 1 month on this default and give him one last shot at trying to work out a deal. But that would be pretty much it for me, because.
So the 1.5 years, not enough yet?
Can I respond?
How long did we negotiate with Baca del Rio when she came in at the 11th hour?
But he's not even here. That's the notion. It's
Because
an email sent on Saturday saying he'd be open to a reasonable fine, which is not even a legitimate offer. He's already, as he's put in the fine information on his letter, rejected what would clearly have been a reasonable fine.
Can I
feel
just
like
respond on one point?
Sure.
We have more sympathy. We do give extensions. We give multiple extensions. We contact people via email to their bosses, call their houses, and put extensive work before a default comes before you. And the fact that he wouldn't even file the statements to cooperate in the tiniest bit just makes me beg for a different resolution.
Again, I think that this is, we're back to the art and the science, right? It's just kind of your feeling of tiredness. And I respect that. I understand. Well, I mean, that's kind of what I heard, but I respect all the effort that goes into getting to this point. I understand the multiple efforts that have gone out to try to get him to work with you. At the same time, I also see some other factors here that I think are mitigating. This is a man, I don't know him, never met him, but from the story that is written in your summary, this is a man who wanted to participate in the political process, had no clue what the rules are. And all he wanted to do was participate in the process, and he got it wrong, which we know is an easy thing to do because we admit that the Political Reform Act is a mess. In fact, we're reforming it. So we admit that it's a difficult system. And yet, when he's saying, I didn't know I was supposed to do this, Aaron, sorry. And at the end of the day, he's now coming back. I understand offers were made. I'm actually kind of unclear though, because in his comment, he says, I'm lost as to what has been offered to him and what the settlement posture is. Well, maybe there is no settlement posture. Maybe it's been taken off the table, but what the last one was, because the last number that was offered to him as settlement when he turned it down, I think you said in February 2016.
We don't actually disclose our settlement offers. He
Okay.
put in his letter what he said. But just in response to what you're saying, he is a political novice, and I will give him that. He also made sure that he didn't have to put a return address on. And when they told him it was a requirement, he put a fictitious address on. And so to ascribe him with any noble notions of adding to the political process in a meaningful way, or to do a hit piece where he hid his identity and intentionally circumvented the rules and then didn't participate in any way to do any meaningful disclosure in order to come to settlement. I think that's how I'm looking at it. And I'm not tired of this case. I don't hear about this case every day. This is not on my to-do list.
Okay.
This is,
That's a good use of resources, I would say.
but for me, the facts of the case speak for themselves.
I just have one, give me 1 second here, Commissioner Wasserman. My personal guiding principle as I sit here, and it may be different from others, but is we do want to enforce the act. We want to make and I think the best way to do it is by making examples of the super egregious conduct, right? Peterson, Mann, Baca del Rio. I agree with those numbers. And to give, I don't know, a parking ticket to the person who got it wrong because they didn't understand the system, which we admit is too convoluted to be understood. But I just don't see how how we can call this achieving success and enforcing the EPA against this tiny little $1,400 violation, when at the end of the day, how that weighs more heavily than the social harm that I think is going to come if we believe him. And I have no reason to not believe him in what he says, the social harm that's going to come from the financial impact that it has on him personally. And then the result that he's going to have to lay off a worker because the fine is too much for him to bear. So now we're putting a gainfully employed person on the street over a $1,400 mailing. I just don't see it.
Commissioner Kasher, did you?
Yeah, I have just a few comments. We like bright lines and we like clear rules, and defaults to me is one of those. this isn't a settlement, a settlement or some form of negotiation where there's mitigating factors and things of the like. You can participate in the process or you can not. In this case, the only issue that I had was that he received proper notice, and I looked at the file and he received personal service of all of these notices, which to me gave him ample opportunity to present himself to the commission, participate in the process, and he chose not to. To me, it's a different issue, his understanding of the Political Reform Act and his actual violation, and then him not willing to avail himself to the process later on, knowing that he's in violation, to defend himself or, participate in some form of settlement. So that to me is a separate issue. He had ample notice of the penalty and he didn't avail himself to the process. I don't have a lot of patience for that, because I think, you can only do so much to try to get them to participate. And if they choose not to, then that's why we have defaults.
Commissioner Wynn?
So he really, in this case, he really had 2 full years, right? The offense was in 2014. So he had all of 15. You began the case kind of mid-year in 15, and then he had all of 16, and there were extensions granted. So, I just am really having a hard time being sympathetic in this case.
So, may I?
Commissioner Wasserman?
Yeah. So let me clarify something. I'm not depicting him as particularly noble or whatnot. All I'm saying is on the record that we have someone who is essentially a pro per type individual. And although I'm familiar with holding those individuals to the same standards as others, in reality, how it tends to work in the courts that I'm in, there's a little bit extra. And what you're telling me is that you've already done that. But I still feel, first off, also his email, I give it, the only credence I give that is it's a communication. As to the actual substance, I have nothing. On the one hand, the commissioner said there's no reason not to believe him, but I also have no reason to believe him. It's simply a communication. And all I am saying is that we have an individual and other individuals. Granted, the chair has made a distinction between someone who shows up and says, I have a check, or I could write a check if we get to the number. One was, I have a check for this amount. I think the other one was, I could write a check as soon as we figure that out. And this is one step down. Well, if you gave me the right number, which obviously is a different world. But I still feel, because of how this person is situated and how we've treated these other folks, that my view, and with no criticism of what you've done so far, I'm just saying, just as I wanted to go a little further one way, I wanted to go a little further the other way, but then cut it there. Okay, and it has nothing to do with whether or not there's one other aspect that is troubling to me about this whole structure, is the chilling effect of this on the individual who is the gadfly or the dissenter or the criticizer. And it really goes to the whole structure itself as to how we have to disclose that you're the sender, and the whole anonymous speech aspect, which appears to have just gone away in our political realm in this context. But here we have a situation where I think we can address, by addressing the leniency, we can address the chilling effect.
Any further comments from the commissioners? Otherwise, public comment on item number 4. Seeing none, is there a motion?
I would just move to put this over to the next meeting for the respondent to have an opportunity to provide. He has to provide us with a number that will for this to settle this matter. And if it's rejected, it's rejected later on. I'm sorry. Let me try to make that into an actual real motion. Motion to carry this one over to the next hearing for the enforcement to continue efforts to settle the matter.
I'll second.
Commissioner, pardon me, Commissioner Adaro,
Yes.
Commissioner Kasher,
No.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
No.
This motion passes.
So I understand the motion or the direction to be to reach out further to this individual for a settlement. And if not, though, I'm unclear what the motion was to bring this default process back. I mean, I'm unclear. We kind of went through this before. Does the default remain pending? Hyla, can you give us some direction? Because otherwise we're
I think
talking
that's-
additional months.
Yeah, no, I think that's right. And the commission has the ability to change the amount on the default, which you could do now.
But it's still a default. So now
Yes.
we're giving a guy a break who didn't show up and with no possible thought if we'll actually get collection on it. Is that? But that
Right, I'm
wasn't the
just saying
motion.
they
The
have-
motion's meant to put it over. So we're
Right.
going to put it over. But the idea is that the default is still outstanding. And I guess if it is not resolved, you can
decide
either
on
bring
the
this back or make another motion, which would require the due process to send it out to him again.
Well, welcome to the world of enforcement. We have 2 weeks till the next agenda deadline. So it would be 2 weeks to settle it before the February meeting agenda deadline.
So, as I said, I wasn't sympathetic to the guy, but I also feel like the burden's on him. I mean, he either comes in within 2 weeks and makes a reasonable settlement offer, or we just put this back on the agenda and take the default next month. That's, in my mind, that's, what I was voting for. So,
And that's how we guess we got the vote. So
All right, so item 4 will be put over. Item 5, eBay.
So this is where I recuse myself. If there's going to be discussion, I think I have to leave, but if there isn't, I think I don't have to leave. Am I right, Hyla? Thank you.
Do the commissioners have any questions or comments regarding number 5?
no.
Is there any public comment regarding item 5? Seeing none, is there a motion?
I move approval of item number 5.
A second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke.
Yes.
This motion passes.
Okay, item 26. Howard Chambers, and I believe Commissioner Odero's recused on
Yes,
this.
same.
Do the commissioners have any questions or comments on item 26?
No.
Is there any public comment on item number 26? Seeing none, is there a motion?
I move approval of item number 26.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke.
Yes.
This motion passes.
Thank you.
Thank you, Ms. West. Okay, so we have the legislative update. Phil's report is just on the 3 bills we have now. Things are new. I'm not sure. Do the commissioners have any question on that report? I'm sure that we'll be hearing a lot more from Phil as the year goes on.
I do,
Okay,
Madam Chair.
Commissioner Wasserman, please.
Thank you. I've looked at each of these 3 bills, and obviously there's some time for things to change, but as presented, I really don't think these are things that the commission should support. I think going backwards from SB 45, I think it's an unnecessary and undue burden on speech in an attempt to sort of close down existing regulatory things, that speech that already complies with our regulation, but then just close that window tighter and tighter. So I don't think that's appropriate, and I think that goes against our mandate to, on the one hand, we're attempting to get disclosure, et cetera, but on the other hand, we're supposed to be mindful of the impact of what we do on speech rights. 2, this sounds like more complexity. to provide for 8 total ranges of fair market value of investments and real property interests and 10 ranges of aggregate value. Wow, that seems like I'm getting some agreement up here about.
I like the rule of thumb: a conflict's a conflict.
Yeah, right. It's sort of, well, it just seems to add complexity. So we're not taking a position today, and we'll see how it turns out. But SB 24, that's a problem I have there. You know what? Good luck with AB 14 in the future. I'll leave it
Thanks,
at that.
Commissioner Wasserman.
Thank you,
Any
Madam Chair.
commissioners, any
Thank you,
other
Commissioner.
comments on the report? Like I said, there will be plenty of time for lots of discussion as it moves forward. Okay, and then we're going to have a presentation from Erin on an update. Erin?
Yes, thank you. So the second part of the package on the ledge agenda item is to update the commission on the rewrite project that we've been talking about for a long time, but specifically really in detail briefed the commission, I think, last February. And so after more than a year, if not longer, of planning and work on the project, we're incredibly excited to be bringing it back to the commission as a final product at this point. And we're requesting that the commission formally vote to sponsor implementing legislation to revise and modernize the Political Reform Act. And the staff memo sets forth the sort of overarching principles and goals of the project and what the benefits that we see. And so I'm not going to go through those again. I feel like we've talked about that quite at length, but it is all set forth in the memo, and I'm happy to answer any questions that the commission has on the process. But I also want to just take this opportunity to thank the partners that we had in this effort. It is a monumental undertaking to redraft an entire body of law. So we first wanted to thank the students and leadership at UC Berkeley and UC Davis Schools of Law, and especially Dean Johnson, who's the dean at Davis, who supported the project from the very beginning, and Professor Carrillo at Berkeley, who came to one of the previous commission meetings. He directed the work of the law students, which was the first stage of the project. And then we wanted to thank that California Forward, who was invaluable to assisting us in just keeping us on target on timelines, and also especially doing outreach, which was extensive, so that we could educate as many people as possible about the project and also solicit as many comments as possible. And we really appreciate their insight into how to do that most effectively and as best as possible. And then we also wanted to thank Professor Brian Garner, who is a nationally recognized legal writing expert, and he was instrumental in sort of the second draft of the project to really continually work on the language to shorten as much as possible, write in plain English, and all of those the goals for the project. And so we also wanted to especially thank all the stakeholders who made comments. We realized that 2016 was obviously an election year. Lots of people have lots of things on their plate, and adding something to already busy schedules is a high ask. So we appreciate the people who took the time to review it and made thoughtful comments. Staff looked at every single comment that was made and carefully considered each comment. And I would personally like to thank the commission staff. We have wonderful staff here who work very, very diligently and very hard through some trying times. And they've spent thousands of hours probably combined on this project. And they, like I said, reviewed diligently every single word of the act, both current law, the first draft, the second draft, trying to make sure that we haven't made have made only non-substantive changes, that we haven't changed the policy of the law. And so, and I also especially want to thank our general counsel, Hyla Wagner, who has personally, I think, looked at every word and has, feels very passionately about this project. And we really appreciate her service on it as well. So as I said in this, the staff memo, we currently have the language into the Office of Legislative Counsel. They are working on putting the final draft into bill form. And we are also in the process of just having many discussions with legislators, legislative staff, and other stakeholders on how best to ensure the bill's success. And so we've been, the chair, Phil, and I have been going over to the Capitol with quite some frequency lately. And so today we're asking as staff that the commission vote to adopt a formal sponsor position to implement the legislation. And we believe that by doing so demonstrates the commission's strong support for the project and its overall goal to increase civic participation. So I'm
Thank
happy to answer any questions.
Thank you, Erin. I just want to concur in her remarks, thanking all of our partners. It really has been a long year plus process, and we are fortunate to have help, and also to concur in all of staff's thank you, but again, especially to Hyla, who's taken a real leadership role in the actual redrafting. And I just think when we started this, we had our objectives, which I think are sound, and again, to reduce technical violations, improve compliance, encourage participation in the process, and strengthen enforcement. But I would just stress now, it seems almost as if this project's coming at the perfect time, with the national narrative of government ethics and a sense of some distrust and talking about conflicts. I think this project is a perfect vehicle to remind the nation that California really does have strong laws and tough enforcement mechanisms when we're repeatedly recognized as national leaders. And it's for good reason. We do have a good system in place. I think this project, making the law easier to understand, easier to see and follow, will just highlight that. So I'm really excited that the project's done right now. So again, thanks to everyone. Commissioner Kasher first.
Yes, I'd just like to also echo the gratitude expressed to staff, Hyla. I love that we worked with Professor Carrillo and the students, and they were involved in it. I was really excited about the project initially, and that was, when we kicked it off, it was nice to see all the students here and great to see that they participated throughout. I attended the public hearing in Oakland, and it was very well attended. There was a lot of really constructive feedback, and I felt like there was definitely an opportunity for members of the public and the regulated community to contribute to the draft that was being proposed. So I think you guys did a great job in executing this from inception all the way through. And thanks everyone for your work on it.
Thank you.
Commissioner Wynn.
Yeah. Oh, thank you so much, Erin and Philip and Hyla. Great job, and thanks to all the staff and really all the participants. I really have a question. I am going to be, of course, supporting sponsorship, but I have just a question about the receptivity that you're finding over at the Capitol for a project like this. Could you just tell us about, could you just tell
How
us
much
a little
time
bit?
do you have?
You mean it's
No.
not just a unanimous thank you?
Overwhelming joy. I think we're in definitely initial discussions. We've had several meetings that were very positive. I think the good and bad thing about this project is that legislators and legislative staff have direct experience working with the act. And so I think, we've talked to some members who have, come up through city councils or whatever else they've been doing prior to being members and, understand, again, they're trying to just fill out the campaign statements. They're trying to fill out their Form 700, whatever they're doing. And so I think that there is a general sense that something like this is needed and that the law has become overly complex unnecessarily. So, I think that's, so I think there's a general consensus that something like this is needed. I think, we're sort of, again, in initial meetings, and I think there also is, just as human beings, resistance to change. And this is something that is changing the language. We obviously are intending it not to make policy changes. So I think some of it's just comfort level with sort of like, this is going to happen. It's going to be okay. And it's a good thing.
I think it's just early in the process, and I think it's a learning curve for the members, and I hope they can get as excited about it as we are. And as we try to stress when we're talking to them, it's our responsibility, this agency, to implement, advise, and enforce this act. And if we believe we can do our job better as a result of this revision project, we hope they can support it. I think it's also just a matter of timing. It's the new year, new members. Both the committees that we deal with, they have new chairs. One committee doesn't even have all their members assigned to the committee yet. So we'll just see as we go through. I'm glad we have it into Ledge Council to give them as much time as possible to work with it. Commissioner Wasserman, Commissioner O'Darrow.
Thank you. No, I just want to say that I want to echo what everybody's been saying. I know that not too long ago, I opened the EPA for the first time, and it was a nightmare to follow it. So I think that this is going to be more than welcomed by people who are trying to do the right thing and follow the law. And this will just help them figure it out. So I applaud all the work that's gone into it. I applaud you, Hyla, to the extent that you've read every word. I bow to you because I'm a regulatory lawyer as well, and my eyes rolled into the back of my head. So no, I think everybody's done a really nice and cooperative job, and I applaud the entire group.
First, I want to say good luck with that process, because when you've done a whole body of law, and especially if you have people who know it or people who don't know it, it's this whole thing. Like, you sure you didn't do something that we don't, that I might have a problem with? So good luck with that. And people can write letters and call people. No, this is the process. It went through all of these processes to get here. And to the extent there are members who were in office and we're getting invitations or we're getting information about this, hopefully that primes the pump for them as to understanding that, no, this just we didn't pull this out of a pocket and say, do this because it benefits us, but that it was a reasoned, careful, deliberate, interactive, transparent process meant to serve the people of California. So I know you can communicate that. I know you have been, but I know it's still going to be a challenge. So the second thing I want to say is to join again also in the thanks to everyone involved in this process. I had the opportunity to go to the Los Angeles meeting, and it's hard to get people out to do legislative and regulatory change. And we have that issue with all of our interested persons meetings, but it was a real push from our end and from our partners to get people in. And then there was some really good comments and good responses, and thoughtful and appreciative responses, because when you get people come in to tell you the thing that they're interested in, and they may not know about this other area or whatnot, I really liked the process, which included a validation of people taking their time and their expertise and contributing it, because that way we keep those people engaged for the process of trying to get this through, but also any other process we have in trying to improve the act. So I thought the whole thing was just very well done, process and product. Thank you.
I will just follow up on that by just saying, so that there's no misunderstanding, just because we have released it to the legislature, I mean, obviously the whole process is going to allow for continued input, and we encourage that. Again, that kind of goes to 2016 was a busy year, and we get it. So if people still feel they have thoughts or comments they want to share, please provide them to us, and we will consider them and incorporate all the comments and suggestions that are consistent with the goals and objectives of the project. So any other comments on this item? No public comment?
Sorry. I just wanted to add to your comment that on the website, which is linked to in the staff report, but it's pretty obvious on the website where it is. There's all of the materials, anything you could possibly want to know about the project. There's red line versions from current law to the final draft. Hyla did an excellent chart that details the regulations that were left into the final draft and why we think they were important to incorporate. There's a conversion chart from the current law numbers to the proposed numbering. And so basically, again, if people haven't had time to look at it, I would urge them to go to that part of the website, and really there's probably more information than you could ever want. But we wanted to put, again, in the interest of transparency, all of it's there. It's still posted, so people can review at their leisure.
In their free time. Okay, is there a motion?
I'll move that the commission adopt a sponsor position on the proposed legislation.
I'll second that.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke.
Yes.
This motion passes.
Great. Thank you, Phil and Aaron. Okay, we have the executive staff reports. Do the commissioners have any questions on the reports? Okay.
I just had one question under the advice letter summaries. It was
Do you have the page?
Yes, page 5. It's second 1A 16226. That an official may participate in decisions regarding a parcel within 500 feet of his residence, and the decision will not have a reasonably foreseeable material financial effect. The specific project, at least the facts presented, the specific project site was beyond the 500 feet, but the parcel itself was much larger than the project. So the project was within 500 feet. Is that how that played out?
Might not be fair to ask. Hyla, did you work on this letter, or do you need to get back perhaps to Commissioner Wasserman?
Yeah, you know what? That's probably a better way to do that.
Yeah, I could get back to you. I think, right, just saying they can measure, right, not to
Yeah.
the entire
Well,
parcel.
then instead, let me do this. We'll track the question here and just
And we'll
highlight it for any one of the 190 people who view this on YouTube on a good month, because obviously this kind of question is, and these kind of letters are the ones that come up again and again. And anyone who is watching should also look at the other letters that relate to when something has a reasonably foreseeable material financial effect.
It looked like they found in this one that even if it was within 500 feet of his residence, it wasn't having any material financial effect. So in that case, he's permitted to vote.
Yeah, the reason this particular one, and then there's another one, they jump into my head because any number of times I've been out and a planning commissioner or a council member comes up to me and says something, and I say, well, first off, I'm not empowered to give you advice on the act, but we have people who are, and these are your different mechanisms.
And I'll just point out that all these advice letters are available on our website. So if someone has a particular question, they can read the entire letter and get a better overview of it.
Right. Thank you.
Thank you. Okay, anything else on the staff reports, or they will be submitted as is? Okay. With that, I will move to adjourn.
Madam Chair, I just wanted to say one last thing because I don't know if this is my last meeting.
Okay.
I
I remove my motion.
Well, no, I just wanted to say thank you to the staff here. It has been really wonderful working with you, and I appreciate all of the things that you do to make, as the chair and as Executive Director Peth has said, to make all of us at the forefront of these issues nationwide. And it's really been a great experience for me, a privilege. I appreciate the collegiality, the ability to disagree and then move on to the next bit of work. And I really appreciate the opportunity to have worked with these commissioners and the very brief overlap I had with the prior some of the prior commissioners. So thank you very, very much.
I would go into a longer thank you, but I'm not confident you're not going to be here next month. So, and that's just the reality. I'll just say we have 3 of the commissioners' terms officially expired January 31st of this year, Wynn, Kasher, and Wasserman. However, the subsequent commissioners have not yet been appointed, so we can have some holdover, which we are hoping they will stay on until they have the next commissioner so that we can maintain a quorum and a full discussion. But was there, sure.
So I was listening to Wait, Don't Tell Me on my way over my drive this morning, and they were laughing about how the president said goodbye too early. And then he hung around for a week and everybody keeps seeing him. And I kind of feel like I might be putting myself in that position, but I would be heartbroken if I didn't say thank you both to my commissioners and to the staff for really making this a great experience. I've really enjoyed 4 years working here, and you've been a big part of it. So thank you very much.
I'll just add that
Again, none of you are going
I know,
anywhere. Okay.
I'm very confident that I will actually be here next month, but it's been a pleasure working with everyone. Staff is incredible. You guys do a really wonderful job in the work that you do, and the commission, the work that we do for the state is extremely important. And I meet people in the regulated community all the time, and the work that we do means a lot to people who, they care about government transparency, and they really care about the work that we do. So thank you guys for all that you do. And it's been a pleasure serving with my fellow commissioners as well, and the chair, and then our predecessors, and Ravel and everyone else. It's been great. So, but I will see you next month.
All right, now I'll move to adjourn.
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke. The motion passes.